So I look forward to hearing all of your questions and hearing what Dan has to say to us today. I'm going to turn it over to you now, Dan, and let you do a proper introduction of yourself.
All right, great. And I'm going to share my screen here in the meantime so I can get that taken care of as well. Perfect. Well, thanks, Cynthia, for that introduction, and thanks everyone for joining. I really appreciate Cynthia hitting the disclaimer for me. I am a lawyer, but I am not your lawyer in this context. But I'm going to try my best to tell you a lot about employment law, which is what I practice in almost exclusively. And I've been practicing here in the Triangle for about 21, 22 years. My clients are mostly businesses, sometimes individuals. Mostly I work with for-profit businesses, but I think a lot of what I'll be sharing today really applies to any business of any type. So that would include nonprofits like a lot of your organizations may be. I certainly welcome questions throughout the presentation. I've got some time at the end where we can address questions, but if there's something that's especially timely midway through, feel free to jump in, and I'll do my best to answer whatever you have for me. So let me talk a little bit about when I say employment law, what do I mean? Employment law is basically the law that attaches to the entire relationship between an employer and an employee. So from hiring to firing and everything that's in between. Those are the sorts of things that I talk with my clients about. We want to hire this person. How do we do that? Now we've got this employee. There are some issues happening during employment. How do we deal with that? What are our legal requirements? To now we want to fire this employee, and how do we do that in a way that hopefully avoids us getting sued? So that's what I'm going to talk about today, starting with the kind of most fundamental question, which is who even is an employee, and who's not an employee. And then once we've identified who the employee is, well, what obligations do I have towards that person? Some of them you know, some of them maybe you don't know. And then lastly, when I need to get rid of an employee, how do I do that in a way that's going to put me in the best situation I can be to avoid any kind of negative outcome with that termination? So let's start with that fundamental point, which is who is an employee, and why does this make a difference? Well, it makes a difference in my world because almost all the obligations that an employer has is our only obligations towards those people who are employees. Someone who's not an employee, like an independent contractor, you usually have no legal obligations to an independent contractor besides whatever your contractual agreement with them says. Similarly, someone who's a volunteer in the nonprofit context, you don't really have any obligations towards them, not in the same way that you would towards an employee. But employee is where obligations start to come in. Obligations like minimum wage and overtime, benefits obligations, and various non-discrimination obligations. So knowing who's an employee and who is not an employee is really very fundamental to understanding, well, what obligations do I owe or not owe to a person? Now, I've shared some definitions here. These are actual definitions from a major federal statute. And what you can see is that they're not very helpful definitions. This federal law, this is from the Fair Labor Standards Act, it says that an employee is any individual employed by an employer. Employee means to suffer or permit to work, so someone who works for you. And an employer is basically anyone who has an employee working for them. I share this to really just emphasize that these are very broad categories, but not very helpful categories. But I think what this tells you is that sort of the default in the law is that someone who has a working relationship for someone else is more likely going to be an employee unless we can establish that they fall into some other category. So when you have someone working for you doing work of some sort for your organization, they're probably an employee. Um, but let's talk about who is not an employee. Well, one key example of someone who's not an employee is an independent contractor. What makes someone an independent contractor? Well, it's a It's a multi-part test, but it is usually someone who is offering their services to the public, and not someone who has a long-term relationship with a single employer. They're not economically dependent, is what the courts sometimes say. An independent contractor has a lot of control over their employment, over the method and manner of the work that they're doing. They're not usually told specifically how to do a thing. They're just told a task to accomplish. They don't receive employee benefits and they're responsible for their own taxes. Let me give you an example because control is one of the most important factors when identifying an independent contractor. If my law firm hires painters to come in and paint our offices, we're going to tell them, okay, paint the offices and we want them painted this color. But we're not going to tell them how to go about painting offices. We understand that they know how to do that. We don't. So we're not guiding them on kind of the actual work. Versus someone who's an employee, we probably are. So if we hire a legal assistant here, we are telling them, well, you need to be here from 9 to 5. This is what our dress code is. You're going to sit here. Here are the various policies that we have. We're exercising a lot more control over that person. That person would clearly be an employee, whereas the painter is not because we're not exercising that degree of control. So it's a way to think about it. Another thing to think about is that independent contractors are not really interchangeable with employees. And so, what I mean when I say that is that you would typically not have the same job being done by an employee on one hand, but also an independent contractor on another hand. That would be a red flag that one of those two is not being properly classified. Either everyone doing this job is probably an employee, or everyone doing a job is probably an independent contractor most of the time. It's not mixed up usually in that way. I think I saw that we had a few chat questions. Oh, okay. I've started addressing that. It sounds like what is the line between independent contractor and a part-time or full-time employee? So that's part of what we're talking about here. And I'll give you kind of the other side of it when we're talking about an employee. Again, an employee is paid wages and they receive benefits. They're usually employed on kind of a continuous basis. They're usually an at-will employee who's just employed until they're no longer employed versus a contractor who might be hired for a distinct project sometimes. Um, with an employee, you're withholding taxes from their pay. With a contractor, you're not. And there's this degree of economic dependence on the employer. And what that means is just usually a person has one job, maybe they have two jobs, but they're relying on that job to provide them the money with which to live versus a contractor who at least theoretically has multiple clients and no one client is sort of their sole source of income, generally speaking. When you're thinking about using an independent contractor or you're thinking about hiring, you know, it's a highly fact-specific analysis. And so I do think you have to be pretty thoughtful to it. One thing to know is that just having a contract that says a person is an independent contractor doesn't make them an independent contractor. That may not get a whole lot of weight in a court's mind at all if the facts on the ground are, despite this contract that says the person's an independent contractor, they're really subject to your control. A court will probably say, well, they're an employee anyway. And it doesn't matter that they maybe even wanted to be considered an independent contractor. It really matters what the facts on the ground are. Um, I'll also add here, I'm focusing on North Carolina law and federal law, but in other states, there are much tighter regulations around independent contractors. So California would be one example. They use a test there called the ABC test. And without getting into exactly what that means, I can tell you that it really means almost everyone is an employee unless you can meet a very high burden of showing that they're not an employee. And while that test isn't used in North Carolina, I think the thrust really is that most people are going to be employees unless you can clearly establish that they are not employees. Now, volunteers, because I know we have some nonprofit organizations here, so volunteers are possibilities. The courts acknowledge that someone who's a volunteer is not an employee, even though they are providing some service to you. If that work is being done on a voluntary basis, if it's done for some humanitarian or public service type of rationale, and there's clearly no expectation of compensation, the court's not going to convert that person into your employee, even though they may be providing service to you. Only for nonprofit organizations, by the way. For-profit organizations can't really accept volunteers. They would be an employee in that context. Where you do have some risk using volunteers is in kind of a dual status between employee and volunteer. If you have a person who's your employee 3 days a week and 2 days a week, they come in and do the same job for you, but you decide, well, we're going to treat you as a volunteer for those 2 days, that's a pretty significant red flag. They can't really volunteer to do the same job that they do for you as an employee some of the other time. Now, they could probably volunteer to do something distinct and different for you as long as you could show that it was truly uncoerced. You're not forcing them to come in and do that. It's truly voluntary and with no expectation of pay. But just something to be cautious about when you do have volunteers, especially if your volunteer is also sometimes your employee. Now, what happens if you misclassify someone? What happens if you treat someone as an independent contractor, but later the IRS or some government agency says, wait a minute, this person should have been an employee all along? Well, it's not great. There are a lot of consequences that are associated with that. The first is what we're going to talk about coming up. All of the employment laws that I'm going to tell you about now apply to this person, and in fact, retroactively apply to this person. So if something has happened or they've been denied some rights that they're entitled to, they're going to have those rights because they were an employee. Second is back pay, possibly. If you haven't paid them and or they worked overtime and you weren't paying them overtime, now that they've been classified as an employee, you're going to have to go back and do that. They're probably eligible for benefits, again, retroactively, potentially. So if they were excluded from your health plan because you thought they were an independent contractor, now they probably have the right to participate in your health plan or 401k, whatever benefits you may offer. Um, and the big one, although it's here at the end of the list, is tax withholding obligations. With a contractor, you're not withholding any taxes. That's great. If the IRS later determines, well, they were an employee all along, the next sentence will be, and so therefore you owe us this much in back taxes and Social Security withholdings, which is going to be an employer obligation to satisfy. So that's kind of the real sort of economic hammer if you do have misclassified workforce. So let me talk about a few best practices if you are going to have an independent contractor to put yourself in the best possible position for that person to actually be found, if anyone is ever reviewing it, to be an independent contractor and not an employee. The number one would be have a written agreement, even though that's not going to be sort of a silver bullet by itself and guarantee that they'll be treated as an independent contractor. If you have an agreement that says they are an independent contractor and makes very clear you're responsible for your own taxes, we're not controlling your work, this relationship is a voluntary independent contractor relationship, that will be helpful. It's also helpful to getting back to the idea of kind of not switching back and forth or commingling employees and independent contractors. Ideally, don't use a former employee and convert them into an independent contractor or have independent contractors do the exact same work as other people who you're calling employees. I know sometimes these things happen. It can be unavoidable in some cases, but the more you can distinguish between these are my employees and they do these things, and these couple of people over here are independent contractors and they do these distinct things on a different basis is helpful to you. Um, with contractors, again, control is important. So not scheduling their time, not telling them you need to be here Monday through Friday, 9 to 5, just we need you to get this job done by X date, but it's up to them kind of to determine. Versus your employees, you may give them a set schedule, and that's fine. Um, Also, segregating files. Employees have personnel files. Contractors, they're just like a vendor. You have a contract in your other vendor files and you keep it separate. Those kind of things are just optics, but yet they can make a difference, especially if it's really close to the line as to the status. How you have treated them can be important in establishing their status. Um, and last, don't reimburse business expenses for contractors. The reason being, a contractor is sort of thought of to be in business for themselves. So they bear their own business expenses. They make a profit or loss based on how they price their jobs. Versus an employee, it's understood if the employee incurs business expenses on the company's behalf, you usually will reimburse that to an employee. A couple other best practices to think about. Um, Avoid benefits in all cases. So a contractor shouldn't have some concept like paid vacation or sick leave or anything, or even really holidays. I mean, not that you expect your contractor to work on Christmas necessarily, but you're just not referring to that in the same way to them that you are to an employee. Again, with a contractor, it's more about independence and their control over the work that's being done. Um, don't give your contractors your employee handbook and say that these are our employee policies and it applies to you too. No, it really shouldn't. Ideally, employees are subject to employee policies. Contractors are subject to the terms of their contract. Um, and ideally, you wouldn't invite them to your employee only events. I mean, I understand if you have a holiday party or something, these people work with you, you might want to include them. But at least ideally, they would be, again, treated as separately as possible from your employee base. And lastly, ideally, don't give them job titles. Again, I know sometimes that becomes necessary for reasons, but again, distinguishing them as much as possible from your workforce, I think is really a good way to go in terms of maximizing the chance that they will be classified as independent contractors when you want them to be. Okay. So I think that's what I've got on the first topic, which is, again, just distinguishing who is an employee and who is not an employee, particularly an independent contractor being not an employee. All right, I have a question here as to whether a paid actor hired for a specific performance with specific rehearsal times is an employee or an independent contractor. That's an interesting question. I think that you could probably make the case that the actor is an independent contractor, notwithstanding the specific rehearsal times, in that the level of control being exercised over them is for a limited amount of time. So there's these many rehearsals prior to the performance. Of course, the rehearsals have to be scheduled, but after that, there's not going to be that ongoing relationship. So I do think that's a little bit different. I also think an actor, it's a unique set of skills that's somewhat distinct from an employee, and perhaps the level of control is not quite the same over the actor's performance of work. Um, Now, I could see it going other ways too. I know a lot of employee actors are treated as employees and they have union contracts to that effect. So I think that might also play into it. Whether you could mix between union employee actors and non-union independent contractor actors potentially. But at least there, I think I would not think the specific performance times would be would be the decision-making factor. And then I have another question about college interns. Okay, good question. Can I give them a stipend for a certain period of time? Can they volunteer other hours during that time? So interns are sort of their own category. Interns can be unpaid. They can be treated as non-employees if their internship is sort of sufficiently educational. And what that kind of boils down to in the analysis by courts is the intern replacing the work that an employee would do, or are they really there more to learn and they're shadowing and they're learning things from different people, but they're not necessarily replacing an employee. Like we fired an employee and now we've brought in an intern and we're going to make this intern unpaid. So I think if they're really more, if it's more about education for them, you can probably make them unpaid or you can give them a less than minimum wage stipend. So we can't afford to pay you, $15 an hour like we'd like to. We're going to pay you $1,000 for the summer and you're going to work this many hours. Again, as long as it's fairly educational, I think you can do that. And if you're a nonprofit, I think that they can also volunteer for you on a non-paid basis. Again, assuming that they've qualified as an intern in the first place and not sort of a paid employee. All right. All right, good questions. So now that we've kind of talked about is who is your employees, let's talk about what are the obligations that you owe to an employee. And there are a lot. Um, Here, I'm just going to run through some of the laws that are the laws I deal with that relate to employees, just under North Carolina law and federal law. The list here on this slide, Wage and Hour Act, ERISA, Fair Labor Standards Act, Immigration Reform and Control Act, etc. These apply to essentially all employers of employees. That is, they, for the most part, don't depend on some number of employees or any real threshold. It's like once you have one employee, these are all laws that you need to be concerned about with respect to your employees. I'm going to talk about a couple of them as we get into the slides. There's a few I'm not going to touch on, but if you have questions about any of these specifically, those are questions I can hopefully answer. Now, there are other statutes that start to apply based on your number of employees. So, for example, in North Carolina, an employer is not required to have workers' comp coverage until they have at least three or more employees. You might choose to have it at two, but you're not required to until you've got three. At 15, two really important federal laws attach, which are the Americans with Disabilities Act and Title VII of the Civil Rights Act of 1964. We're going to talk about both of those laws and what obligations they impose, but they come in at 15 employees. At 20, another federal law kicks in, which is the Age Discrimination in Employment Act. We're going to talk about that one as well, but for whatever reason, Congress decided that one starts at 20 rather than 15. Also, COBRA, which is the law that, among other things, requires continuation of health insurance benefits, at least at the federal level, that kicks in at 20 employees. I should say that in many states, there are laws like these federal laws that come in lower. So, for example, in many states, the disabilities protection under state law kicks in at one employee or five employees. That's not the case in North Carolina, which is why I'm not going to talk about it too much. But if you're operating in other states or if you have employees in other states, you may be covered by some of these types of obligations, even where you're not at the federal threshold of 15 or 20. And to that point, I guess I should mention, let's say you're a North Carolina-based organization. You've got most of your employees here in North Carolina, but for whatever reason, you've hired one employee remotely in Virginia. What law applies to that person? Well, the answer is Virginia law applies to that person. You're now an employer in Virginia with respect to that employee in Virginia. And so just because you have that one, you now need to figure out, well, what laws in Virginia might apply. They may have some laws that don't kick in until five employees in Virginia. Okay, you don't have to worry about that. They may have other laws that apply as soon as you've got one employee in Virginia. So it's really where the employee is working that drives which laws apply to you. So just again, I'm not going to talk about sort of state by state differences, but that's something to keep in mind as you may have remote employees. And then getting up into some of the larger numbers, which, I don't know if any of your organizations will reach these, but at 50, the Family and Medical Leave Act applies. That's a federal law that requires up to 12 weeks unpaid leave of absence for certain medical conditions, also childbirth and other related types of needs. So that kicks in at 50 plus employees. And then at 100 plus employees, there are two requirements: EEO-1, which is a federal informational filing that is made for larger employers, and then the WARN Act, which deals with layoffs and kind of plant closures and that sort of thing. So probably not as relevant, but again, just goes to show that as an organization grows, legal obligations also grow with the growth of the employee base for sure. So now let me get into a couple specifics of what some of these laws that I just ran through, what do they actually mean? What obligations do they impose? So I'm going to start with wage and hour laws, which there's both federal law and a state law. So both federal and North Carolina state law require payment of a minimum wage, which is currently $7.25 an hour, federal and state. And those laws require overtime pay, which is time and a half after 40 hours in a week for employees that are exempt, and for non-exempt rather. I'll talk about what the exemptions are in a minute. But if you have a sort of regular hourly non-exempt employee, these are your minimums, 725 and overtime after 40 hours. I should say that for private businesses, so not government employers, overtime has to be paid in cash. There's no like comp time. You've worked extra this week. We're going to give you a little more time off next week. Sometimes employers do that, but that's not permitted. The employees have to be paid actual cash for their overtime after 40 hours in a single week. So, as I indicated, those overtime and minimum wage requirements apply to non-exempt employees, which probably leads to the question of, okay, well, who is an exempt employee? Who don't I have to worry about, particularly overtime with? Well, an exempt employee, there's various different exemptions, but they have two basic requirements. One is you have to perform exempt duties, and the other is you have to be paid a minimum salary. The minimum salary level is $684 a week as kind of a guaranteed, has to be at least this much of a salary. And a lot of people think that, well, if I pay someone a salary, they're exempt. And it's not that simple. So I've got a couple things that I'll say. If there's one thing you take away from this, this should be it. Well, this is probably one of those. Don't assume that just because someone is paid a salary, they're necessarily exempt from overtime. Being paid a salary is part of the requirement, but it's not all of the requirement. The other requirement is that they have duties that are what the law accepts as being the type of duties that can make someone exempt. The most common are executive, administrative, and professional. I'm going to talk a little bit about professional later because it kind of applies specifically to arts organizations. Executive means I'm someone who manages people in the organization. I manage at least two people, and I have significant discretion in how I manage those people and the part or all of the organization that I manage. Administrative is confusing. It doesn't mean administrative in the sense of like administrative assistant. It means running a part of the business. So, like HR is a function of a business that could be considered administrative as long as the person exercises enough discretion. I think that confuses people sometimes because it suggests that like again, sort of administrative tasks become exempt. It's not that. It's running a part of the business. And then professional, it covers two kinds of professionals. One is what they call learned professionals. So lawyers would be an example, doctors, architects, engineers. The other is creative professionals. And that's where you've got your artists, your actors, designers, things like that that are exercising a creative talent as an employee. So we'll talk about that shortly. Again, just to touch on the salary part of the requirements, that's the first half. The employee has to get a guaranteed salary of at least $684 a week. It can't be subject to reduction because of the quality or quantity of the employee's work. So if a salaried employee works only 3 days one week, that basically means they still need to get their whole salary because they aren't an hourly employee where the amount of time they spend changes their compensation. The idea of this is a guaranteed minimum. And similarly, just because they don't do a good job, you can't use the bad quality of their work to say, well, we're going to reduce your salary this week, generally. Those kinds of deductions can cause a person who would otherwise be exempt to become non-exempt and therefore entitled to overtime. When we talk about the duties, the other half of the question of who's exempt, the focus is on their primary duties. So, what do they spend most of their time doing? And if they spend a little bit of time doing something that's non-exempt, like part of the time they're moving boxes in a warehouse, but the vast majority of the time they're supervising people and they hire and fire, they can still be an executive, even though they may do a little bit of stuff that is sort of non-executive. Um, Importantly, though, this is a lot like employee versus independent contractor. It's not just based on a label that we apply. We say a person is exempt and so they are exempt. No, a court's going to look more closely and say, no, what are the facts on the ground here? What is this person really doing? And do they qualify as exempt or not based on their actual duties? Um, and I do want to touch on again the creative professionals. I think this may be relevant to you all. This is a particular subcategory of exemption. So if someone's paid on a salary basis and they are using their artistic abilities, their imagination, their inherent talent or originality to kind of create a work or otherwise engage in an artistic endeavor, they can be exempt on that basis. So you see the examples here: actors, musicians, a composer, painter. Maybe you tell them the subject matter, but you're not telling them how to paint the landscape or whatever. You're just telling them paint a landscape. Okay, that person's probably going to be a creative professional and they're going to be exempt. And again, when I say exempt, that basically means exempt from overtime and sort of time tracking requirements. Whereas a non-exempt person is probably being paid by the hour, they're clocking in and out. An exempt person is not. I saw that I had a few questions. Let me see if I can get those up. Sorry. Well, here we go. All right, so first question was, what does handling employee injuries at under 3 employees with no workers' comp insurance look like? Well, so without workers' comp insurance, what it would look like is it would be kind of a negligence-based standard, the same as if you were operating a store and a customer came in and slipped and fell, basically. So you wouldn't have that insurance coverage that workers' comp provides. And when you have workers' comp, it's the sole remedy that an employee has for their workplace injury. They more or less can't sue you because of the injury. They have whatever they get from workers' comp, whatever that may be. If you didn't have workers' comp because you were under 3, it would be similar to if a customer gets injured at work at a place of business, they could sue you for that. And so that's why I think if you have 2 employees, you might still be thinking, well, maybe I want to have workers' comp insurance anyway, just in case that were to happen. And then I have another question here about, are the employee numbers FTE or do part-time employees count when determining the number? For the most part, all of those numbers I was running through are full and part-time both count. It is employees on payroll. Um, Usually it's for like a number of weeks. If you had this many employees on your payroll for 20 weeks in the last 2 years or something like that. But it's any employee, full-time or part-time for most of those laws. And I see a follow-up here about going back to the injury question. Would that be the same for volunteers? Yes, I think generally that's right. If a volunteer was to be injured, they're not going to be covered by workers' comp, even if you have it, because they're not an employee. So it's just sort of a general negligence standard. They could possibly sue you like a customer could sue a store. You might have some kind of liability insurance that might provide some remedy there, or at least provide for the cost for you if that person was injured. I know a lot of times organizations will have volunteers sign a waiver that may provide some protection against those sorts of claims. I don't know that that's going to be perfect in all cases, but it might be something worth considering. All right, I have another question here. Let me see what this one is. If we have a couple of employees who work 20 hours a week and are hourly, but occasionally go over on their time, can they use that extra time as comp time, or must they be paid in cash? I know if over 20, it must be over 40, it must be in cash. So good question, Kim. If it is within the same week, you can do a form of comp time. So you have someone who normally works 20-hour weeks, but Monday and Tuesday they put in really long days for whatever reason. Within the same week, you could give them time off that week. It's really only a problem if it's crossing into an alternate week or they've gone over 40 hours. So what you wouldn't want to do is they work 30 hours in one week and then say, well, next week we're going to only pay you for 10 because you worked over here. I would try to avoid crossing the weeks with that. But within a week, you do have some flexibility to say, hey, you worked a little extra early in the week, take some time off at the end of the week, or vice versa. That would be fine. Okay, I think I've hit the questions for now. So let me talk about, most of what I was saying before was the Federal Fair Labor Standards Act. North Carolina also has a law, the Wage and Hour Act. It's similar in terms of it also requires overtime and minimum wage, but it also has a few other requirements. It has requirements on how often wages are paid, so weekly, biweekly, monthly, at least monthly. It requires disclosure of wage payment policies. That usually happens like in an offer letter or maybe in an employee handbook. We pay our employees every other Friday or what have you. And it this is important, has requirements about the forfeiture of wages. So what that looks like is, some employers may have a policy that says something like, if you leave and you don't return a cell phone that we issued you, we're going to deduct $500 from your final paycheck or something like that. That is more or less not permissible, or at least it's very difficult to make that work without a really clear policy and maybe a signed document. Um, or another example might be, what about vacation? Some employers will have a rule that says if you've got accrued vacation and you leave, we pay out the vacation. Others say we don't pay out the vacation. That can be okay in North Carolina as long as you've got a written policy to that effect. I think the main idea to take away from that is you should be very cautious with anything that causes you to take earned wages away from an employee. And it would probably be worth consulting with a lawyer before you're going to do that to make sure you're doing it in a way that's permissible. And in other states beyond North Carolina, it's actually even harder to do. So in California, for example, you just pretty much can't take employee wages for any reason, even if you loaned them money and you want to get it back from them. You can't take that out of their pay either. They just need to write you a check. So just something to be wary of, I think. The Wage and Hour Act, by the way, just to emphasize, applies to all employers. So any size, once you've got one employee, this applies to you. For profit, not for profit, everybody is subject to this. Now, if you don't comply with the Wage and Hour Act, you're going to be liable for a couple of things. Number one, the employee can sue you for the wages that you haven't paid them. But if they win, that number is going to be doubled. It's called liquidated damages. It basically means the court is going to double the damages, and you're going to pay interest plus the employee's attorney's fees, plus you've presumably also paid for your lawyer. So, even a really small amount of wages that is not paid can turn into kind of a big case. I mean, there are actual reported cases where the employee sued and won like $100, but the court also awarded $25,000 in attorney's fees. So that dispute over $100 turned into a much bigger case. So I think that, wage payment is not something to really mess with, or at least have a lawyer and be really confident if you're making a decision not to pay someone something that they think they're owed, because that can really add up pretty quickly. Okay. So I'm going to touch on now some of the federal anti-discrimination laws. Now, these are some of the ones that kick in at higher levels, so 15 and then 20 employees. But I think where they do apply, they're pretty significant, and they impose a number of restrictions. The first is called Title VII. It's Title VII of the Civil Rights Act of 1964. This is the basic anti-discrimination law that applies to employers in the U.S. It prohibits discrimination based on race, color, religion, sex, and national origin. With respect to sex, that has been interpreted to basically include sexual orientation and gender identity as well. So although that's not completely settled, it's settled enough that you should be assuming that those things are equally protected by this statute. This, as I say, prevents discrimination, and that can occur in a couple of different ways. One is something like disparate treatment. Basically, you couldn't treat a black employee worse than you treat a white employee on the basis of race. That's kind of obvious, but that is the kind of first way that it applies. The other way that it applies is something called disparate impact. This is where you have some policy that on its face seems neutral, but in practice, it could have some effect that skews more heavily towards a protected classification. So it's a seemingly neutral policy, but it actually negatively impacts women and benefits men in some way. That's probably discriminatory, even though it's not on its face, we're going to treat women worse than men or vice versa. So those are kind of the two main ways that discrimination can occur. And again, this law prevents discrimination on all these bases. I should say, too, sometimes you hear people talk about protected classes, and that means these categories, but it doesn't mean any subset of these categories. And so what I mean is someone who is a white male is equally protected by these laws as someone who is a Hispanic female, let's say. This law says you can't discriminate on the basis of race, not minority race or certain races. It's all races, it's all sexes, any gender, that's all protected by the law. And then the Age Discrimination in Employment Act, the second big federal discrimination law. This one prohibits discrimination based on age. It only applies to employees who are 40 years old or older. I don't know exactly how 40 was chosen as the cutoff, but you become protected from age discrimination at 40. You are not protected at 39, at least under federal law. Um, Again, it's a similar sort of thing. You can't overtly discriminate against people that are 40 and older, but you also can't have policies that have the effect of discriminating against people who are 40 years old and older. Um, how this one most often comes up is through like job postings, for example. Like you're not going to say we won't hire anyone over the 40, but sometimes they'll say things like looking for recent college graduates with fresh ideas and high energy. Those kind of coded words that suggest we want young people and we don't want older people can be evidence of age discrimination. And if an older candidate is rejected from that kind of a job posting, it would not be hard to imagine them saying, well, this was really code for they didn't want someone who was 41 in this job. And so I've got an age discrimination claim. And then the last of the big three federal statutes is the Americans with Disabilities Act. So this one prohibits discrimination against people with disabilities. But this one goes further and implies some affirmative obligations on the employer. So first, it requires reasonable accommodation. So if you have an employee who has a disability, you have an obligation to provide them with a reasonable accommodation, as long as it doesn't create an undue hardship. And we'll talk about exactly what that means, but the basic message is you have to be willing to work with someone with a disability. You can't have a blanket rule that says, well, we can't deal with that. We can't handle having someone here who has X condition, so you just can't work here. Like that kind of a policy is not going to fly. This law also implies some limitations on the ability to make medical inquiries of your employees. And the reason for that is courts and the law doesn't want the employer to know more than they should about the employee's background. And it's really good for you as the employer to not know more than you should a lot of times. If you don't know that someone has a disability, it's hard for you to discriminate against a disability you're not aware of. Once you start asking for information about a disability, well, now you're more informed. Um, Although there are limits there, it's also true that once someone comes to you and says, I need an accommodation, I have severe migraines, I'm going to need time off from time to time when I have a migraine. Once that subject has been broached and you're discussing the accommodation with them, that's when you actually are permitted to ask some medical questions and kind of say, okay, we hear you. We'd like to get some information from your doctor. Tell us about this condition. How long will it last? How often is this going to come up? It's allowed in that context because now you're working on your accommodation. You've got an obligation to accommodate. You need to understand what are the parameters of what I'm being asked to accommodate. What is the nature of this condition? That's when you are actually permitted to start making those inquiries. Okay. So let's talk a little bit about, well, what is a disability? It is very broadly defined in this law. It's not something sort of transient or passing like, having the flu or something, but it's any physical or mental impairment that substantially eliminates one or more major life activities of an individual. That's the kind of official definition. Major life activity is very broadly defined as well. I mean, it's anything from like standing, walking, caring for yourself, eating. It's also the operation of bodily functions. So, like breathing, I have trouble breathing. If it's a substantial limitation on breathing, that's a disability. So, really, any kind of long-term condition is probably a disability. It's not just obvious things like blindness or deafness would clearly be a disability, but so would something like diabetes is a disability, or any kind of long-term condition, MS, cancer. Um, Mental health concerns are also likely disabilities. So someone who's diagnosed with major depression, OCD, PTSD, anything like that probably qualifies as having a disability. Interestingly, alcoholism can be a disability as well. Current drug use is not considered a disability. So if you have someone who is a current user of illegal drugs, they are not entitled to protections of this law. But someone who's a user of alcohol, an alcoholic, would have the protections of this law and would be entitled to some accommodation. Um, I think the main thing to know is it's pretty broadly defined, and unless it's something really transient, probably someone has a disability. And so when I'm advising employers on, well, this person says they have such and such condition and they want an accommodation, we pretty quickly skip past the do they have a disability question to what accommodation do they need, and can we give them that accommodation? Because that's where the real analysis happens. Here are some examples of things that could be accommodations when you have an employee with a disability. I mean, a lot of times what they are changing the work schedule in some way, giving a leave of absence, letting someone have additional breaks during the day if they need it to accommodate their disability. What you don't have to do is sort of take away essential functions of the job. So if someone is in a role that, has to be on site because part of what they're doing is, working with equipment that is in a facility and they've got to be there, they can't say, well, I need to work from home as a reasonable accommodation because, well, no, in your role, it's literally essential that you be here handling this equipment or whatever, running this machine in a factory setting. So an essential function you don't take away, but a non-essential function you might. If one thing that they have to do is some small portion of their job, and accommodating their disability would be don't do this one thing, that might be something that has to happen. Um, the main thing I think to know about accommodations is it really requires dialogue between the employer and the employee. A discussion about what do you need? What can we maybe do? Well, we don't think we can do this. Maybe we could do this over here. It's a discussion. There are regulations from the government that require that kind of interactive process. And so that's what I think if you have a person raising that question, have a discussion with them. You don't have to give them exactly what they would prefer as the accommodation. You have to give them an accommodation that's reasonable and likely to be effective. It doesn't have to be exactly what they want, but it's worth having the discussion with them. There's good guidance on the internet. The Job Accommodation Network is a resource that is available online that gives examples of when a person has this condition, here are the sorts of accommodations they might need. And so, if you're a little bit of a loss of kind of where to start, that would be a place you could look. I'll also mention on this front, a person doesn't have to say any kind of magic words to trigger this. They don't have to say, I have a disability protected by the Americans with Disabilities Act. I need a reasonable accommodation. They're not likely to say that. Some people might. They're more likely to say, hey, I've really been struggling with X and I need some help. And if you're, a manager of an organization, you should probably have your antennas go up, start asking some questions to understand, okay, what's the nature of what they're dealing with? What are they asking for? If they're asking for any kind of modification to their job, you should probably assume, okay, we're in ADA world now, and I need to be thinking about this as a reasonable accommodation, assuming you have 15 or more employees and you're covered by the ADA. Oh, good. Yeah, I see that Beth just put a link to askjan.org. That's the website for the Job Accommodation Network. That very helpful information there. Okay. Let me talk a little bit about discrimination. As I said, these three laws, Title VII, ADEA, ADA, they all prohibit discrimination based on their different protected categories. So any decision that affects the terms, conditions, or privileges of employment, if it's based on one of those protected classifications, that could be discrimination. So hiring and firing are sort of obvious ones, but also promotion, job assignments, things within the job. If you're giving someone better duties than someone else, and it's alleged to be on the basis of race or color or age or what have you, that could be discrimination. And compensation too. So if you're paying people differently, do you have an explanation for why people are being paid differently? If you have a business justification and it makes sense, then that's probably fine. That's defensible. But if there's not a clear explanation and people find out, well, women in this role are paid this, men in this role are paid that higher amount, people are going to assume that sex is playing a part in that decision-making process, barring some evidence to the contrary. So it's worth thinking when you're making these decisions, do we have an appropriate justification for why we're acting this? And this is kind of why, if you're working with an employment lawyer, and you say, hey, I want to fire so and so. They've been performing poorly, so here's why I want to let them go. And one of the questions your employment lawyer is going to ask is, well, what have you done in similar situations in the past? Because what we're trying to suss out is, are you treating similarly situated people the same, or is this breaking new ground? We're treating this person differently than we've treated people in the past. And then I'm going to ask, well, why? Why is this case different? And if there's a good explanation, I might say, okay, that sounds reasonable. I think you can terminate this person with, relatively low risk. If there's not a solid explanation, I'm going to say, well, no, I would recommend let's treat this the same as we've treated past situations. Maybe we need to just do a warning here. We're not quite to the point of termination. Again, that kind of consistent treatment across history helps to ensure that you don't end up with a discrimination case. All right. So let me talk a little bit about harassment. You've probably heard of sexual harassment, other sorts of harassment. How does this fit into the discussion of discrimination? So harassment, the law looks at as a form of discrimination, basically. The statute itself does not say the word harassment. It's something that courts have kind of read into the law that says, if there's a harassing type of behavior in the workplace, it can amount to discrimination. Um, there's sort of two ways that that can happen. One is when it's connected directly to a term or condition of employment. And so that looks like sort of you have to accept this harassing behavior to keep your job. Or do you want to get promoted? If you want to get promoted, you need to do X. That kind of harassment, kind of the quid pro quo harassment, you don't see as often anymore, but that's kind of the first example of harassment. The second kind of category of harassment, the more common one, is what's called a hostile work environment. And this means that there is severe or pervasive conduct within the workplace that would cause a reasonable person to consider it to be intimidating, hostile, or abusive on the basis of a protected classification. And I say that last part because it's really important. Employees will sometimes say, this is a hostile work environment. And what they mean is, my boss is mean to me. And my boss being mean to me is not necessarily legal harassment. That might be a problem in the workplace, but that's not necessarily a legal problem unless it's my boss is mistreating me and he's mistreating me this way because of my sex or because of my age or because of my disability. That's where we have a legal problem. So it's that hostileness, that severe or pervasive conduct based on a protected classification that's critical. Now, when we say severe or pervasive, there's no kind of clear standard for exactly what that means. The more severe an incident is, like the picture here on the screen, the more likely it will be found to be harassment, even after just one or two incidents. Less severe conduct, maybe it's got to be repeated a lot of times. So, you think about an inappropriate joke, you know, one time, that's probably not harassment. Doesn't mean it's okay, and a manager should probably be dealing with it, preventing that from happening, saying that's not okay in the workplace. You can't say a joke like that. But if it's one time, that's very unlikely to be hostile work environment. On the other hand, something like trapping a person like this or touching, that might be harassment just on the basis of a single incident. Yeah, similarly, using racial slurs like the N-word, I think courts recognize that's at a very high level of effect on the workplace. So one or two uses of a slur like that in the workplace might constitute harassment, whereas some other comment that's not that bad doesn't, at least not until it's been repeated several times. Importantly, when you're talking about harassment, this is often in the context of like a supervisor harassing a subordinate, but that's not the only way that it could come up. Coworkers can engage in harassment. It can also be a third party in the workplace. So, a customer or whoever, a third party, a vendor that's in the workplace, if they're engaging in that conduct towards your employees, you, as the employer, have an obligation to make sure that that conduct doesn't continue. Once you know about it, you need to take action to put a stop to it. Um, it doesn't have to be targeted. So, for example, two people talking to each other about sexual conduct and a third person overhears them, even though that third person wasn't the target, so to speak, of their conduct, the fact that they're talking about it in the workplace and the third person feels uncomfortable, that too might rise to the level of harassment. Um, so it's broadly defined, and I think this is why, employers should have harassment policies so that you're outlining, hey, we take this seriously. Here are examples of the sorts of things we don't tolerate. But also importantly, if you, the employee, think that you've been subject to harassment or you've seen harassment, here's ways that you can report that. And here's how we're going to address those concerns. If you report it, we're going to investigate. If we investigate, we're going to take appropriate action once we've conducted our investigation. All of that's really important, both from a point of view of we want to treat our employees the right way, but also from the legal side of things, it's going to help me provide you a better defense if I can say, we had a policy, we trained our employees on the policy, but this guy was still a bad actor. And once we found out about it, we fired him. That's a much better case than we didn't really deal with anything until it blew up. And, now what are we going to do? Just some examples here of potential harassing conduct. I mean, I think most of these you can imagine how they might be. I mean, this isn't to say that a court is, as I said, ever going to find like one single incident of some off-color comment or something is going to always be harassment, and the employer is always going to be on the hook for it. I think the message is really just you want employees to be thoughtful about how they're interacting with people in the workplace, and trying to avoid even coming close to the line of something that someone might think was harassing conduct. Okay. Well, the last bit here on the discrimination topic is retaliation is also illegal under all of these statutes. And so what retaliation looks like is an employee reports, hey, I think I'm being harassed by my coworker. This is what's happened. You, the employer, look into it, you investigate, you determine, well, maybe this wasn't appropriate, but it didn't amount to harassment. We're going to give a warning to the harasser, and that's going to call it a day. You couldn't then also say, and we're firing you, employee, for raising this concern. That kind of retaliation for raising a complaint of harassment or raising a complaint of discrimination would be unlawful under the statute. So anytime someone is making a complaint under any of these laws, you need to be very cautious before you take any negative action against them. It doesn't mean you can't. It just means you need to really be confident that you've got good documentation. We're not terminating them because they made a complaint. We're terminating them because they come into work late every day and we've warned them about it and they keep doing it. And we always terminate people who come into work late. That's why we've hired them, not because they made a sexual harassment complaint. Okay. And I think that is the end of the section on some of the legal requirements. So let me talk now about terminations. Um, you have probably heard, well, we're an at-will employer. You've probably heard of at-will employment. This is an employment at-will state. And in fact, the Department of Labor on its website says in North Carolina, the employer can discharge an employee at the will of the employer for any reason or no reason at all. And that is all true. Um, but there are many, many exceptions. And we've been talking about some of them, right? So the idea that you can't terminate someone because they've complained about harassment is a big exception to employment at will. The idea that it says here we can terminate you for any reason or no reason. Well, sure, but we can't terminate someone who's over 40 because they're over 40. That's a big exception to employment at will. So I think the thing to know is that yes, we are an employment at will state. Every state in the United States is, except for Montana. You can fire someone for any reason. You can fire someone for a stupid reason if you want to, or no reason. But there are almost so many exceptions to this that you still need to be cautious when you fire someone. When an employer talks to me about someone that they fired who's now coming back and raising some sort of complaint, you know, I'm going to ask, okay, well, why did you fire them? What did you tell them when you fired them? What documentation do you have around the reasons that you fired them? If we have a legitimate non-discriminatory reason for the termination, that's the legal language I'm going to use, then I'm going to feel pretty comfortable that, well, they might sue you, but they're not going to get anywhere with this case. And I'm going to tell their lawyer it's not even worth your time to file the lawsuit because we've got this documented. This happened. This is the reason we fired your guy. It's kind of the end of the story. There's nothing to it. Um, where do I have a problem in making that case is when you tell me, well, we told them it was a position elimination, but then we replaced the person right after that. And I mean, yeah, performance wasn't great, but no, we didn't really document it. Everybody knew the performance wasn't there. Now I start to have a problem because I don't have a whole lot documented to work with. You've told them one thing, but maybe that wasn't true in terms of the reason for the termination. That's where you start to have some issues. So I think step number one for you as the employer is documentation is the key, right? Establishing why this person was terminated, and ideally, if it's something like poor performance or attendance issues, that there's some history of we gave them a warning, we gave them another warning, they kept on coming in late or what have you, and then we fired them. There's no magic number like you have to give them 3 warnings and then you can fire them or anything like that. It's just a matter of they knew the issue continued. We've got written proof that just puts me or your lawyer in such a great position to say, hey, there's nothing here. If it isn't documented, you can be sure the employee is going to say, no one ever told me I had any problems. In fact, they told me my performance was great. I thought everything was perfect. I'm shocked that I got fired, right? Documentation is really the key. That bears a lot of weight in court. And documentation doesn't have to be super formal. It doesn't mean we need some formal 2-page write-up document in some particular format. It can be as simple as an email, right? Like, Jane, as we discussed today, your attendance has really been problematic over the past couple of weeks. You've missed 3 days and you haven't given us any explanation. We really need you to be here. That kind of email is documentation that, hey, we had the discussion. We explained what our concern was. If that continues to be a problem with that employee, you've got a basis to move forward with terminating. Now, when you have the termination meeting, I probably wouldn't conduct it quite like this guy is, but the most important thing I think is to tell the employee why they're being fired. That doesn't mean you need to give them a 30-minute narrative of every bad thing they've ever done and here's the whole history. But I do think it is helpful to tell the employee why they are being let go so that they hear what the reason is. Especially if we're not going to change the reason, right? If we're going to stick with that. If that's the real reason they're being fired, let's go ahead and tell them this was not a rash decision. We're letting you go for this reason. And that can be it can be a short explanation, but there should be some explanation given. It's a great idea to have a witness with you if you can. So like in my larger, private companies, that's usually the manager and some HR representative. But in a smaller organization, just someone else with some level of management authority, 2 people in the room is usually better from the company's point of view. Be discreet as much as you can, conduct it in a, office out of the way, not in front of everybody as best you can. Sometimes it's done by Zoom these days. Be firm and no debate, right? You've got to go in with the mindset of this decision is made, it's final. The employee may not like it, and that's okay. The employee sometimes needs to get some stuff off his or her chest. That's okay too, but you're not going to change your decision here. And then take precautions. What I mainly mean by that is like be prepared with an action plan. Once someone is terminated, How are we getting their laptop back? How are we cutting off their access to our IT systems? Do they have a key to the building? Worst case, is there a concern of violence? I mean, that's not often the case, but occasionally it will be the case. Do we need to call someone to be here, like security wise? I've definitely had clients that have had to do that in a few cases. It's not common, but just being thoughtful about what is our risk level here and how do we cover those things, I think can be really helpful. But again, then documenting what has happened afterwards, right? Um, Today we met with Jane to let Jane go. We let her go because her attendance has been terrible. And here's the history of that. That's like a simple 3-line memo to the file or email between the two people that were there, just so that we have that documentation of what happened and what we told that employee on the way out the door. And with that, I think I have come to the end. Now, I've covered a whole bunch of topics. I actually haven't covered every single employment law topic. There are actually a lot of other things I deal with too. But I'm happy to answer any questions about something we've talked about, something we didn't talk about that's relevant to you, anything you've got. This is your time. So put them in the chat or feel free to unmute yourself and speak.
Dan, thank you so much. This was super interesting. And I do want to say, folks, I do feel like Dan addressed most of the questions that were in the chat. If you feel like your question did not get addressed in the chat, please really unmute and just ask it. Or if that doesn't work for you, you could re-up it in the chat just so that we see it. But I thought it was so comprehensive. I feel like I really understood that. And years ago when I was an employer, I was actually given the advice not to tell the employee why you were firing them, but to just fire them. So,
Yeah, I do think people sometimes give that advice, and I think it's a mistake because I think it can cause the employee to just react even more negatively. They're already not happy that they're being fired. And if they can't even get a reason out of you, it's just one more thing for them to stew on and assume that it must be some negative, unlawful reason. I'd rather own up to, like, no, sorry, you just weren't doing a good enough job. And if
yeah.
that's the case, say so. Okay, here's a question from Denise. Can you discuss initial probationary periods? Is this a wise practice? Can you terminate someone in that period because it isn't a good fit? Um, so my take on this is I generally tell people not to use a probationary period, and here's why. I feel like it can set an expectation with the employee that something changes on day 91. You've got a 90-day probationary period, and somehow on day 91, our relationship is different now. From my point of view, your relationship isn't different on day 91 than it was on day 90. You're an at-will employee on day 90, you're an at-will employee on day 91. So if you're going to do it, I would just be cautious with the language and just say that, hey, during this initial period, we're going to review your performance really closely, and it's a learning and training phase, but don't give any sort of expectation that something different will come to pass after they've exceeded that period. Um, you know, can you terminate someone because it isn't a good fit? I will say as to that, it's probably better to terminate someone if your rationale is, hey, it's just not a good fit. I would do that sooner rather than later because that's pretty hard to explain if they've been there however long, 18 months, and it's like, oh, we just decided this isn't really working out. That doesn't hit as a really good explanation to me. And I, as your lawyer, would push for more like, what is going on here? Whereas, if it's 2 months in and it's just like, well, this is not going to work out. If you know it, then it might be better to just go ahead and make that decision sooner, if it's pretty clear.
Well,
Did we? Oh, go ahead,
I just
Denise.
wanted to say thank you so much, Dan. This has been so helpful to
Of
me.
course.
I've been employing people in nonprofit for 30 years now, and you've just clarified so much for me. Thank you.
Well, I'm glad to do that. Thank you for saying so, Denise. Anyone else? Happy to answer any other questions anyone may have.
We have a question from Beth about best practices for recommendations for hiring, which
Okay.
is, yeah, definitely part of employment law. So
Yeah. Yeah, so good question. I mean, I think there, one of the places that can be a foot fault is I don't know if people are using background checks or credit checks even with people. There are legal requirements that apply to getting a third party to do any kind of background checking. And that includes like letting the person know that you're doing it, getting their consent, and only doing it fairly deep into the process. So at your initial stage, you wouldn't really be asking people, for a background check until you're much further along in the process. Similarly, when we think about disability questions, if you're, and this may not apply to a lot of your employees, but some of my clients, they have physical requirements. We operate a manufacturing facility. You have to be able to lift 50 pounds. You can say, hey, can you lift 50 pounds with or without reasonable accommodation? But you can't go into with someone at the early stage of hiring. Tell me about your medical conditions. Why can't you lift 50 pounds? What accommodation do you need? That's got to come later in the process so that you're not sort of, again, gaining more information than you should have. The other thing I'll comment on is the states are heavily starting to regulate the use of AI in hiring. So we don't have this in North Carolina yet, but a lot of states have started adopting laws that say if you're going to use AI to screen applicants, you have to let people know, and you have to have an AI that has been sort of vetted so that it isn't creating discrimination by however it's weeding people out, for example. So I don't know if you're using any sort of automated processes, but if so, stay tuned on that because that is clearly an area that's ripe for more regulation.
we have a question from Charmaine in the chat.
I see that.
Yeah.
I'm an attorney in the workers' comp space and on the board of a couple of nonprofits. Do you co-counsel on plaintiff employment issues? So we do not really represent any plaintiffs here. What we occasionally represent individuals like they're signing an employment contract or they've been fired and they need help with a separation agreement. We don't really represent an individual if they're filing a lawsuit. In those kinds of cases, we only stick to the employer side, not the plaintiff side.
Okay, thank you so much.
Of course. Okay, I see a question here from Hillsborough Arts Council. Is there a meaningful distinction between part-time and full-time? What is considered full-time? Not huge distinctions. From the legal standpoint, there's a couple ways that it can matter. A lot of times in the benefits space, benefits will not kick in for someone who is not a full-time employee. And in that regard, 30 hours a week, a regular schedule of 30 hours a week is the usual standard. So people who are under 30 hours a week are usually not eligible for like health insurance, dental, those sorts of things. And then 401k can sometimes be excluded based on like a total hours number. Like I think 500 hours or something is now the standard. But there's not a lot of differences. It's really more about your policies. So for example, vacation. A lot of employers will say full-time employees get this much vacation, part-time either don't get paid vacation or it's accrues at some different rate. That's fine as long as you define it and there's no legal standard. It's more you decide as the employer what is your standard going to be.
Thank you.
Oh, Dan, we've opened the floodgates now.
I see.
Yeah. People just had to think. They had to think about their questions. So.
That's fine. How comprehensive do you recommend a small company's employee handbook be? I would say this, at 15 or more employees, you need to have a comprehensive employee handbook because now you're covered by some of the federal discrimination laws we were talking about earlier in the presentation. And so at that point, I think you need to have like a real employee handbook. When I say real, I mean it's probably 25 to 35 pages. It covers everything, it covers harassment in particular. If you're under 15 and you think, for the foreseeable future, we'll probably stay under 15, I think then you could probably have a less comprehensive employee handbook, but I would still be setting out things like what are our rules around vacation? What are our expectations in terms of attendance? I'd still probably have a harassment policy, even if you're under 15, just because I feel like that's such a potential area for liability. So while it maybe isn't as comprehensive, I wouldn't say you're sort of out of having an employee handbook at that point. Easy one. Yes, the materials will be available to download, or at least we can make them available. Cynthia, maybe you can help with that, but yes,
Yep.
that's no problem from my point of view.
Yeah, I can add those to the link, folks. Just a reminder, I will be sending you all a link here probably in the next 48 hours to a recording of this that you will have access to for 30 days. This also will be appearing on our YouTube channel. We put most of our Lunch and Learns up there. That takes a little bit longer. That's why I send the recording directly to participants, but I can definitely toss your slides in on that email as well, Dan. Thank you.
Sure. Perfect. And then I see Erica has a question. Are there any legal issues suggesting or telling an employee that another organization or job may be a better fit, but not firing them? I think I would say there's not necessarily any legal issues with that as long as it's not being motivated by one of these unlawful discriminatory things, right? So yeah, as long as you're really thinking, hey, this isn't a great fit, we might eventually have to move towards termination, but we're trying to be kind of a little nicer and suggest that the employee might want to look elsewhere. I don't see that as a big concern. But I do think you maybe at that point, if you're saying that and they don't get the hint, you probably have to be prepared in the near future to actually take some action. Because I do think firing too slowly is a problem, right? So like, let me share that. Like, yeah, you don't want to fire someone precipitously without documentation, but at the same time, I don't love seeing a case where it's like, well, we had 18 months of really poor performance, and now finally in month 19, we decide to fire the employee. That kind of suggests that you weren't too worried about the poor performance if you let it go on that long. So while there is this sense of we need documentation, we need to give people a chance, and I agree with all of that, at the same time, don't let it go on too long. If someone isn't working out, they're not performing up to your expectations, you do need to make that decision at some point, some reasonable point.
Well, Dan, it looks like we've exhausted their questions. So,
Okay. Well, my contact information is in the slides. And so if anyone wants to reach out, discuss something further, or if you have a legal need that you actually need help with, I'd be happy to do that too. So feel free to do that. I really appreciated talking to you all and sharing this with you. So thank you very much for the opportunity.
thank you so much, Dan. On behalf of Triangle Artworks and everyone in the call, we really appreciate the help that you've given us and all the work you do for arts organizations in North Carolina. We appreciate that so much.
Thank you.
So folks, thank you for joining us today for this Lunch and Learn. I appreciate you being here. If you are not already a subscriber to our newsletter, I highly recommend it. We do Lunch and Learns throughout the year. They are always free and they're always really topical information, really targeted at you, at arts administrators or artists. I'd also welcome you to take a few minutes to look around our website and see if there's anything else that might be helpful to you. I will be emailing you with that recording pretty soon. So thanks for joining us today.